Hereby, I open this academic ceremony in which Jarin Nijhof will defend the academic thesis entitled How to Serve Two Masters, Conflicting Treaty Obligations in Cases of Dual Membership of NATO and the European Union. And I welcome the audience here in our aula, and I also welcome everyone participating in this academic ceremony online. Good to have you. Dear candidates, may I invite you to present a summary of your study and the conclusions of your thesis.
Thank you, Pro-Rector. Dear Pro-Rector, highly esteemed members of the Corona, dear colleagues, dear friends, dear family, here and online. Today I have the privilege and the challenge to guide you through the contents of my dissertation, which is the result of an intensive 5-year-long research endeavor. Since the Russian invasion of Ukraine in February 2022, both NATO and the EU have been in the center of attention. The invasion confirmed that Russia imposes a threat, a serious threat, to European security. Against this background, Finland and Sweden even reversed their long-standing history of military non-alignment and joined NATO in 2023 and 2024, respectively. Both NATO and the EU have substantially enlarged since their respective foundations in 1949 and 1958, resulting in a considerable overlapping membership. NATO and the EU currently consist of 32 and 27 member states respectively, 23 of those states being member of both NATO and the EU. In my dissertation, I refer to the latter category as dual NATO-EU member states. A biblical maxim teaches us that one cannot serve two masters. Indeed, opposing treaty provisions can demand different things and may lead to divided loyalties. After all, acting in compliance with one treaty may at the same time result in violating obligations under the other treaty regime. I therefore loosely base my title of my dissertation on this maxim. Moreover, the aforementioned dilemma led to the following research question. How do dual NATO-EU member states resolve conflicts arising from their obligations stemming from NATO membership on the one hand and EU membership on the other hand? Mindful of the African proverb that giant elephants are best tackled by eating them bite by bite, I have examined a number of sub-questions in order to answer the overarching research question. First, I examined the characteristics and legal status of the treaty regimes of the EU and NATO and their interrelationship under public international law. Next, I analyzed the state of law regarding conflict resolution under public international law. In addition to the relevant provisions of the Vienna Convention of Law of Treaties, I also examined the conflict clauses of the NATO and EU treaties, Article 8 of the North Atlantic Treaty and Article 351 of the Treaty on the Functioning of the European Union, the TFEU, respectively. By means of the Court of Justice of the European Union, the CJEU, the EU has a judicial institution that is empowered to interpret EU law and whose decisions are binding on all EU member states. In view of this, I specifically researched how the CJEU interprets the scope of Article 351 TFEU. As NATO lacks a similar judicial body, I also analyzed what instruments are available to individual NATO member states within the NATO legal framework to remedy conflicts with EU law. And lastly, as NATO treaty obligations are inextricably linked to the national security of its member states, I deemed it relevant to research how the CJEU interprets the scope of the national security exception under EU law, as provided in Article 4, second paragraph of the Treaty on European Union, the TEU. After I analyzed the basic legal framework by means of researching the aforementioned sub-questions, I put this doctrinal basis to the test by examining a number of examples of conflicting treaty obligations. The examples show that conflicts have arisen and may arise in areas such as military mobility, military procurement, environmental protection, mutual legal assistance in military criminal cases, budgeting, and the processing of personal data, to name a few. This brings me to the key findings of my research. First, this research finds that both NATO and the EU are international organizations with no existing hierarchy among them. Next, the legal relationship between their treaty regimes is governed by the applicable conflict clauses. After all, these conflict clauses identify the parties' intentions in this regard. The EU's conflict clause, as provided in Article 351 TFEU, embeds a so-called subordination clause, making prior treaties prevail over EU law. In this context, it is significant to note that until recently, all dual NATO-EU member states had joined NATO before acceding the EU. However, Finland and Sweden were the first two states to join NATO while already being member states of the EU. This has actually created a legal conundrum, because Finland and Sweden, as opposed to the other dual EU-NATO member states, cannot claim precedence of their NATO obligations pursuant to Article 351 TFEU, since their NATO obligations do not predate the obligations that apply to them under EU law. In my dissertation, I note that this matter can in fact become topical if the long-winded dispute between Turkey and Cyprus would flare up again. After all, most NATO... excuse me. I have some difficulties with the mouse. There. Excuse me. In my dissertation, I note that this can be topical. After all, most dual NATO-EU member states must in such case take side with Turkey, because the latter is a NATO member. If Cyprus, however, which is a member state of the EU and not of NATO, would on the other hand invoke the EU's collective self-defense clause, which is introduced in the Lisbon Treaty and which resembles the well-known Article 5 of the NATO Treaty, this would arguably require Finland and Sweden to take the side of Cyprus. As such, an unintended divisive issue is arguably lingering. In regard to the scope of Article 351 TFEU, the CJEU has taken a very restrictive approach. The CJEU has, for example, repeatedly opined that Article 351 TFEU does not apply between two or more EU members. Accordingly, EU law always applies to any dealings between them. My dissertation, however, shows that this restrictive approach clearly cannot be upheld in the context of certain NATO treaty obligations. This is, for example, the case in regard to mutual legal assistance in criminal cases, which are governed by the NATO Status of Forces Agreement, the NATO SOFA, which predates EU law. As a result, the European investigation order is not applicable in such cases, not even between two dual NATO-EU member states. In addition to a... I apologize. Sorry. Yeah. I apologize. There. In addition to a powerful court, EU law also provides for a compelling enforcement tool by means of the so-called infringement procedure, which can result in financial sanctions. In view of this, dual NATO-EU members may, in fact, feel inclined to apply EU law, even when of a later date, and even if this violates concurrent NATO treaty obligations. Unfortunately, the NATO legal framework provides for little counterweight. Considering NATO's political nature, most NATO treaties prescribe negotiations between the disputing parties without recourse to outside jurisdiction. In this context, the North Atlantic Council only serves as a last resort to adopt an authoritative interpretation. This recourse, however, has never been utilized. Lastly, when interpreting the scope of the national security exception, the CJEU equally applies a restrictive approach. In the context of personal data protection, for instance, the CJEU has strictly curtailed EU member states in their efforts to collect personal data in bulk, under the pretext of protecting their national security. In turn, a number of EU member states proposed certain amendments to the draft e-privacy regulation in an apparent attempt to effectively reduce the impact and arguably even set aside the restrictive ruling of the CJEU. This is indicative of the political sensitivity when it comes to interpreting the scope of the national security exception. The recent accession of Finland and Sweden to NATO only underlined the relevance and importance of the national security exception. After all, as the conflict clause of Article 351 does not apply to these two dual NATO-EU member states, they can only rely on the national security exception in any cases where EU and NATO treaty obligations prove incompatible. In conclusion, the overarching research question can be answered as follows. Under international law, conflict clauses in treaties play an important role in resolving possible norm conflicts. However, given the CJEU's restrictive interpretation of Article 351 TFEU and the possibility of infringement procedures under EU law, dual NATO-EU member states may nonetheless be inclined to prioritize EU treaty obligations over certain NATO obligations, even if the conflict clauses provide otherwise. Moreover, Sweden and Finland arguably cannot invoke Article 351 TFEU. They, in contrast, will thus have to rely exclusively on the national security exception to stipulate the non-applicability of EU law. Given the lack of an institutional court within the NATO framework, similar to the CJEU, this paradoxically results in an inequality of arms in favor of EU law when it comes to resolving conflicting treaty obligations. In view of this, it is not surprising that the examples that were examined show that, although a few cases have been litigated before the CJEU, such as in the case of military procurement, most of these conflicts are resolved through diplomatic means, that is, by bilateral or multilateral negotiations between dual NATO-EU member states and bodies of the EU or NATO. As such, while both the NATO and EU treaties provide for a legal solution to such conflicts by means of conflict clauses, final resolution is mostly achieved through negotiations rather than by court decision. This leads to a number of recommendations. In order to balance the scales between NATO and EU interests and to ensure the rightful application of the applicable conflict clauses, it is recommended that in the event of conflict in treaty obligations, an individual dual NATO-EU member state should partner up with other dual NATO-EU member states. By voicing a joint and comprehensive position, an individual dual NATO-EU member state can substantially strengthen its leverage. Alternatively, an individual dual NATO-EU member state may also consider elevating the matter to the NAC to see its involvement. After all, the NAC has the power to adopt authentic interpretations of the NATO treaties and other rules of the organization. Lastly, while the substantial coordination initiatives of NATO and the EU in regard to military mobility are applauded, the examples analyzed in this dissertation show that EU-NATO consultations are desirable and necessary in many other areas to prevent dual NATO-EU member states from being faced with conflicted treaty conflicts in the first place. These recommended avenues should as such ensure that dual NATO-EU member states can continue to wholeheartedly serve both these masters. This concludes the summary and key findings of my dissertation. Thank you for your attention. I now hand it back to the Pro-Rector.
Thank you so much for your presentation. The opposition will be opened by Professor Otte. Professor Otte is Professor of European Union External Relations Law, and she is also the chair of the Assessment Committee.
Thank you, Pro-Rector. Dear candidate, first of all, congratulations to your thesis. This has been an achievement being on the mountain now and looking down into from this hill. It's also impressive that you try to address a very complex topic looking into international law, in European law, and trying to resolve or making suggestions on possible how to resolve these conflicts. My first question is devoted to a prime example you give at the beginning of your thesis, from page 70 to 74. This concerns the example of the short case, where you give this as an argument also to highlight the treaty conflicts and the increase of treaty conflicts, so the fragmentation of international law, and how to reconcile different obligations. The example you bring, the short case, which was tried in a court, is a case in the Netherlands where there was a military officer who had committed supposedly a murder, and the US authorities asked to extradite him. But then the Netherlands decided under the ECHR, the Convention on Human Rights, not to do that, or at least find a reconciliation on that problem. My question is, because this is about the ECHR, and on the one hand, and the NATO status agreement, which you also mentioned in your presentation, what does this example teach us for the EU and NATO obligations? So how far is this a very important and outstanding example for treaty conflicts?
Yes.
Thank you.
Highly esteemed opponent, thank you for the question. Yes, if you go back in case law, what you will see is that there is little to none about NATO conflicting treaty obligations. And actually, if you look in literature, you'll see the same thing, that there's hardly any case law involving NATO or NATO obligations, except for the short case, indeed, which is also discussed in literature on NATO obligations, on a handbook on the NATO SOFA, for instance. It's elaborated in that context. Because it was so important, because it is actually one of the first cases that show a possible conflict between NATO obligations, which in the context of the short case was that countries, they made an arrangement that they would waive cases in regards to service members to in certain contexts. And whereby the Netherlands then said, no, but we are bound by a human rights convention, if we would transfer this case, it would actually have the individual be potentially subject, because it was a murder case, potentially subject to the death penalty. And that is something that we cannot do because we not only signed up to the convention, but also to a protocol abolishing the death penalty. So that is why this example was one of the first, and indeed is mentioned in my thesis, which was not so much EU law, but the Convention of Human Rights. However, what you'll see is that NATO SOFA does not mention any NATO or human rights in itself. It's a document from the 1950s. And this example clearly shows that with time, a lot of things develop and evolve. And so when the human rights and the view, for instance, on the death penalty have evolved, that is where then suddenly this conflict with NATO SOFA arose. And this is the primary or first example of a possible conflict with NATO treaty obligations. The NATO Status of Forces Agreement being one of the most obvious and probably also directly affecting one, because if you look at the North Atlantic Treaty, that of course has hardly any very binding obligations to individuals. But this was a case where an individual saw his rights, his human rights, then violated in his sense, and that is where the short case became pivotal. Another important thing is why this is also so an important case is also this case shows that whereas there are conflict clauses on both sides, eventually the result of the case resulted in a diplomatic resolution, because what happened is that the Dutch, from a legal position, they did not want to transfer the individual release him to the U.S. authorities, military authorities, and only after negotiations between the U.S. and the Netherlands, where the U.S. military authorities agreed that he would not be subject to any death penalty, were the Dutch then eventually agreeable to transfer him to the military authorities.
Okay, yeah, but I mean, but then primacy has to be given to human rights. So you would agree that this is kind of the overarching principle,
that is the question. That brings me back, or that would, and I did not understand that right away from your question. But if that is your question, that brings me back to another chapter, the previous one. If you look in international law, there is no hierarchy. What it was is that the Dutch signed up to these conventions, the human rights conventions, at a later time than the NATO SOFA. So from that perspective, NATO SOFA would prevail. The discussion of whether, for instance, there is a hierarchy with human rights, that's a different one, which I also briefly touch upon. Thank you very much.
Are you satisfied with the answer? In that case, the opposition will be continued by Professor Wessel. Professor Wessel is Professor of European Law at the University of Groningen. We also consider him a friend of our law faculty, but today he is here as a member of the assessment committee. And in that capacity, I very much welcome Professor Wessel to Maastricht. Please, you have the floor.
Thank you very much, Pro-Rector, and it's always a pleasure indeed to be in Maastricht. Dear candidates, I read your thesis with great interest, and I think it addresses an issue that has been largely overlooked, NATO-EU obligations and then the tensions between those two obligations, or the many obligations, in fact. And you've dealt with that in a very comprehensive manner, tackling almost everything that there is to say about that. In that sense, it's also a clear contribution to the existing knowledge, and it's also obviously increasingly important. So I'm pretty sure that you are one of the few people that are actually happy with recent events because they make your thesis more relevant. I'm, of course, referring to the US elections and the aftermath of that. Questions. My main question, I think, relates to something you already indicated, Article 351. It's a key element in your whole argumentation. You describe Article 351 TFEU as a subordination clause, and rightfully so, I think. But you also suggest then that on the basis of that, NATO holds a higher legal standing, or NATO rules hold a higher legal standing, simply because the NATO treaty predates the EU treaties. Well, this may have been the original intent of 351, and I agree with that at the time. One could argue that at least after nearly 70 years, this effect was not meant to persist indefinitely. In fact, one might even contend that member states have failed to fulfill their obligation in the same article to take all appropriate steps to eliminate incompatibilities. So they have not lived up to their own brief in that sense. Situation has changed. And the question then is, given the unique, you could argue, constitutional relationship between the European Union and its member states, at least from an EU perspective, you could argue that it's always EU law first, that EU member states are EU member states first, rather than being states first, if you want. The very identity of EU states has changed the moment they became a member of the European Union, whereas their NATO membership has not undergone any similar transformation. So that perspective would in fact turn your claim upside down and have significant implications also for other concrete situations, including the one you also mentioned in your introduction, that most EU member states should side with Turkey in the event of a conflict with Cyprus. Such a stance would appear to indeed disregard the constitutional relationship between the EU and its member states. So I would like to hear your view on the sort of temporal effects that may have put us in a position to reassess Article 351, given the constitutional development of the European Union.
Right. Highly esteemed opponent, thank you for the question. I'm just thinking of where to start this thing. I think that 351 TFEU in itself already has a sort of an ambiguity, because indeed, as you mentioned, the first paragraph mentions that there is this subordination clause for any member states, and then in the second paragraph, under the loyalty to the EU, you have to then try to erase these incompatibilities. However, what the problem is, and that is also some of the scholars also indicate that, I think it was Klabbers also who mentions this, is that Article 351 TFEU in that sense actually is very difficult to apply for multilateral agreements, because the only way that you would even be able to do so would actually be to step away from that other treaty, so to terminate that treaty, which of course for the NATO treaty is yeah, I mean that's hypothetical, highly hypothetical, and will never happen. So to that extent already, I think that what you will also see in case law of the CJAU is that the CJAU itself is sometimes struggling of making treaties apply the second paragraph of 351 TFEU, because it's so difficult to do so in the context of the NATO treaty obligations, for example. And one thing that I think that a lot of scholars share that fact, the fact that the NATO treaties go back 70 years, the conflict clause was also in the Rome Treaty, but that doesn't change the fact that from a legal perspective, it is a conflict clause and a subordination clause, which the fragmentation, the ILC, the International Law Commission, also points specifically that it is accepted as being the conflict clause in EU law. So to that extent, from a legal perspective, it still stands, albeit that there is an ambiguity in the conflict clause itself already. I hope that answers your question, sir.
Yes, partly, but if I may to just add follow-up. Yeah. So I can follow that. That is the clearly legal approach, which disregards, at any case, I think, the sort of passing of time and the developments that we have seen in the European Union, constitutional development, as I called it before.
Yeah.
So would that constitutional development have no effect at all on the interpretation of Article 351, in your opinion?
I think it will, and I think it does. And I think, and then getting back to your introduction, I think it actually may very well be in this moment, because I think that we're now living in times where the world is upside down again, and that the interpretation that you might now from an EU perspective look at and say, hey, we have to adhere much more to the loyalty, and we have to adhere much more to EU law and NATO because it's 70 years old, we may have to refocus. Well, I would actually argue that indeed over time things may change, and I think that we're actually currently seeing that. I think that some other powers to be may have a very different approach. And for instance, if we look at budgeting, NATO and all the countries have to pay more for NATO. Well, guess what? If you would ask the CGU on that, and if you put the template of 351 with that, especially the second paragraph, well, guess what? You would definitely get into in a vacuum, because you can't move. Eventually, there must be a decision, which again may not always be the legal one, but also a political one.
Now the opposition will be continued by Dr. Nauta. Dr. Nauta is Chief Institutional Law Team at the Allied Joint Force Command in Brunsum. We, as a faculty, greatly value the cooperation that we have with your team. You're here also as a member of the Assessment Committee. And I very much would like to welcome you on behalf of our university here to Maastricht. Great to have you, and you have the floor.
Dear candidate, your research on conflicting obligations under EU and NATO rules is relevant and timely. And the EU's presence is felt in everyday's life. The freedom of movement of persons, capital, goods and services not only affect individuals, but certainly also NATO and its member states. Recent sanctions imposed by the EU against Russia affect the political and military security of European allies, and the movement of military equipment of NATO member states through the US, through ports of Rotterdam, Wilhelmshaven and Portsmouth, through Poland into Ukraine is regulated by the EU. Your research provides insightful meaning to the interaction between NATO and the EU and how their member states implement their respective, sometimes colliding international legal obligations. I highly appreciate the work you presented, and I might say this as part of the workforce of NATO, surely NATO and its member states will benefit from this academic and practical achievement. To my questions, the thesis mentions in Chapter 2 various institutional mechanisms in order to resolve potential norm conflicts between the EU and NATO. Chapter 3 concludes that NATO lacks entirely an institution to resolve such conflicts. At the same time, the thesis concludes that the EU's mechanisms, the CGEU, is neither perfect. Absent an unflawed institutional conflict resolution mechanism, the CGEU seems to impose due diligence obligation on the EU in the Kadi case, where it states that the EU should take into due account of obligations that member states have under the UN Charter. Admittedly, the EU has taken into account the obligations of dual NATO-EU member states when promulgating EU regulations and directives. In your view, is there an obligation of due diligence of international organizations not to create normative conflicts in the first place? And how do you see that working out in practice?
Sorry, can you repeat the last sentence? Sorry.
Is there an obligation of due diligence of international organizations not to create normative conflicts in the first place? And how do you see that working out in practice?
Esteemed opponent, thank you very much for the question. I think that, yes, due diligence is on both sides. By the way, I think we also have to understand, for instance, if we talk to NATO, dual NATO-EU member states, again, from a NATO perspective, if you look from a NATO perspective to these countries, you can't ignore the fact that they have implemented, well, partly implemented EU laws or are just subject to regulations to EU law directly as such. So that is a fact of life, as the other highly opponent mentioned. Over time, these things evolve. And I don't think, what you see is that NATO is not blind, is not turning a blind eye on that. For instance, if you look at personal data protection, whereas there are immunities, so the NATO headquarters as such have certain immunities and privileges, they do have now issued, promulgated directives that you will see reflect the GDPR, which is EU laws, to a certain extent. Not being bound to it, not being subject to it, but nonetheless applying it. Of course, I mean, you have to understand, for instance, their workforce, a large part of their workforce are citizens of EU countries, dual NATO EU member states. So as such, it is not a strange thing. And I think that in fact, what you will see is that in NATO indeed, as an organization, does apply due diligence also in regard to environmental protection, into other examples that I discussed in my dissertation, to a certain extent. To the extent feasible and possible. However, what you will see is, for instance, if you talk about environmental protection, that there's always this caveat of operational necessity, where they will then have to waive or just set aside any such laws. Does that answer your question, sir?
Thank you very much.
Thank you so much. Now the opposition will be continued by Professor Fisser, who is assistant professor in the field of international law here at our university, and who is also a member of the assessment committee.
Thank you, Pro-Rector. Dear candidates, first of all, I will join my colleagues in congratulating you on finishing this interesting piece of research, especially as you were combining it with work, family life, and undoubtedly other activities as well. So that is a remarkable achievement. It should not be unaddressed. Leaving the questions of purely EU law and NATO law to my colleagues, who are much better equipped to ask these, I will focus more on public international law. And it mainly relates to your first sub-question and the second chapter of your thesis. So your first sub-question reads, what is the interrelationship between the EU and NATO legal regimes under public international law? And essentially my question is, what is the answer to this sub-question? Thereby focusing on the issue of hierarchy. So not norm conflicts, but hierarchy. Because this is not entirely clear to me. And I'll try to explain why, and I'll repeat my question at the end. So for example, you talk about the hierarchical relationship between the NATO and EU treaties, yet do not determine exactly the place of general public international law within the EU legal order, which seems a fundamental determination to make in your thesis. And additionally, as was mentioned before, you mentioned human rights, especially linked to the Cadi case, of course. So when human rights are at stake, does this impact the potential hierarchy between EU law on the one hand, and on the other, either specifically the NATO treaty or public international law more generally? And linked to this, and referring to the Cadi II CJEU decision, you mentioned that, and I quote, there is a large consensus among scholars that the CJEU's approach seemingly violated Article 103 of the United Nations Charter. But how come? And how does this impact the hierarchy of public international law and EU law? Final example, in Chapter 3, the 6th section, you again analyze this interrelationship, but you focus on treaty interpretation there rather than hierarchy. Yet in your conclusion, you do state, by lack of any prescribed hierarchy between treaties under public international law. And I'm not entirely sure what that conclusion is based on, nor what its implication is for the relation with EU law. So my question comes down to the following. What, is the hierarchical relationship between EU law on the one hand and general public international law in general, or the NATO treaty specifically, on the other hand? Thank you.
Esteemed opponent, thank you very much for your question. Well, in short, my conclusion was, and I think I stand by this, is that there is no hierarchy, except for, and that is maybe the point that you point out, is that there is a sort of a, let's put it, a consensus under scholarship that there may be some kind of preference if human rights come into play. However, if you keep that in mind and then go back to one of the earliest questions of the previous opponent in regard to the short case, I think that some other powers to be might disagree with that. So I think that there is no consensus to that extent, because there it also the question becomes, what is the human right, and to what extent is it then, for instance, customary law, or is it jurcogens, so where there is indeed a hierarchy under international law, also set by the UN Charter. But so the question of what the hierarchy is, for instance, the example that you mentioned in the CGEU and under 103, I think that also there you will see that certain scholars take that position, other scholars do not. The end of it there being is, again, besides the legal question of whether there is a hierarchy or not, the outcome there was that eventually the UN bodies did make changes to their procedures, resulting in a framework which would better suit the concerns of the EU, the CGAU in this case, who had concerns of human rights protections of an individual involved. So I think that from a legal perspective, there is no hierarchy to that extent, other than maybe human rights, that there is a consensus. But other than that, there is no hierarchy, because also the question is, where do you look for that, and where is it codified, the hierarchy of this in international law, and that is where it brings to you that in essence, there is no hierarchy between NATO and EU treaties as such.
Are you satisfied with the answer? In that case, the opposition will be continued by Professor van der Meij. Professor van der Meij is Professor of European Social Law at our university. Please.
Thank you very much. Dear candidates, congratulations for having written a wonderful book, a thought-provoking book, and a question-provoking book. My question basically deals with the issue or the topic of judicial activism and creeping competences, which you discuss in chapter 3. You refer to authors who have criticized the Court of Justice for stretching the competences of the EU legislator, and basically also for overstepping its own competence. In this regard, you refer to cases like Kadi, Schrems, KD and KS, and even Bosman, the football case of Bosman. And that triggered right away, that is one of my favorite cases. Why is that judicial activism? But more in general, you don't have to talk about Bosman. But with all these rulings, you mention them, summarize them rather briefly, and you state that authors think this is judicial activism. But you don't really analyze it, and I'm curious what your own views are on this, which you don't really work out, I have the feeling. For example, the KD and KS case, there the court says that it does have competencies in matters that do not directly relate to political and strategic choices. What is the problem here from a judicial activism or competence perspective? Is not one of the main reasons why the CVSP is a separate pillar under which the court does basically not have jurisdiction? Precisely because this is a field these are fields where political and strategic decisions have to be taken. What's the problem with the conclusion of the court that there is a power to review a decision on the hiring of personnel of an EU mission? What's the problem with that? Why is that judicial activism? So basically I would like to know what you actually mean with judicial activism and why in the field of your study, whether you can elaborate a little bit on why you think it is problematic. Because to be quite frank, I'm not right away persuaded by that. Huh? Oh. And then a little thing, if I may add that, it was also because of your last slide were recommendations. Basically, you say that the NAC, the North Atlantic Council, must be engaged. What do you mean by that? When I read your book, I also came across that suggestion, and I understood it to mean, but maybe I'm wrong, that the Court of Justice should engage a political body like the NAC. Yeah. As if it must have the same dialogue, let's say, as it has with the Strasbourg court. And that I thought, you cannot be serious. Are you? I guess.
Highly esteemed opponent, I am. No, sir. And thank you very much for your questions, and I'll go over them one by one. First, on the judicial activism. Judicial activism, my thesis is not focusing on judicial activism, nor should it actually, and nor would I want to focus on it. However, what we do see is, or what you see specifically from a NATO perspective, is that the CJU has taken an approach and has ruled in certain cases which seem to be pretty activists. Maybe not bending the rules, but interpreting always the effet utile, making, bending or interpreting to the extent that it favors the EU and its mission. However, so the chapter or the paragraph that you mentioned on judicial activism, I pointed out because it is actually a step up to, for instance, on the national security, where you have Quadrature du Net and you have another quite a lot of judicial rulings there. Those are from time to time problematic. Not only they are problematic, or that is where even the EU, some EU member states at some point say, hey, the CJEU may have overstepped its competence here, because, for instance, if it comes to national security, that is something that the member states consider a competence of their own, and also the EU treaty considers it a competence of their own under Article 4, paragraph 2. So to that extent, that is where the relevance of the judicial activism comes up. Judicial activism also, if you look at literature, it is not always, it's not a bad thing. Actually, it's actually exactly what we expect from the CJEU, that the EU expects and all the member states expect from the CJEU to be, is to protect, whatever they made, and that it is protected from deterioration. However, it should still also be within the parameters of conferred competences. And that is where, and that is how I nuance it also, judicial activism in itself is not bad, but it should not become competence creep, to the extent that you actually encroach upon competences that you should not be encroaching on. So that is where the judicial activism, it's not per se that I take the position that that is a negative thing, or that you cannot expect it from a court, quite the contrary. However, when it comes to competence creep, and some of these, indeed, I mentioned them also in literature, they're mentioned as examples. I'm not going into the weeds of all these cases, but later on in the national security exception chapter, there I do look at some of these cases, and some of these cases, that is where the competence creep also from the EU member states. For instance, the matter of the EU privacy regulation that I mentioned, the example where the Council actually makes an amendment specifically referring to certain CJU rulings that they wanted to clarify, which is interesting because generally it's not the Council clarifying CJU rulings, but generally the other way around. And then to your other question about the NAC and being engaged, and I apologize, I hope that my dissertation is clearer than my presentation then, but engaging, it should be engaged by the dual NATO-EU member states. So they should engage, actually they should just elevate matters to the NAC. This is maybe something that we can later talk with our NATO colleagues, because whether this is a merely hypothetical thing, because the question, again, the NAC has never ruled on any disputes before. It's never been, because it is all countries are in the NAC and they rule by consensus. Well, it's a matter of, A, do they feel this imperative and important enough to rule on it? And B, would they actually go public with it? Or would it then, which again my thesis shows in many cases, is that the end result will mostly be through diplomatic channels, so that the public would not know of how we eventually resolve the matters. But that is what the essence or the recommendation for involving the NAC is, because it's just the highest possible body of NATO to engage, so they could then reach out to either the EU or whatever and go public with that. And to that point, by the way, also what I did mention is that the CGEU, they could from time to time maybe more proactively look for amicus curiae, so for the friends of the court, for interpretations, because there is a case, HMRC versus Able, where the CGEU interpreted the Paris Protocol, which is an interesting thing because it's a NATO treaty, and the CGAU did so without consulting with anybody of NATO. So that is something where I do think that it goes both ways.
Are you satisfied with the answer?
Yeah, but maybe my follow-up question, I will come back to. If I have the time for a second question, I might come back to this issue. But it's not my turn yet, I think.
Well, in that case, I am indeed happy that we do have some time, because I have the feeling that some committee members would still like to delve a bit deeper into some of the issues discussed before, or some other issues. And I first would like to give the opportunity to Professor Wessel to do so.
Thank you very much, Pro-Rector. Yes, indeed, I'm the lucky one who can start a discussion on the national security exception. Realizing that I was not the only one bringing that topic up in the questions and the discussions that we had. I will try to be brief to allow for follow-up questions as well. Your book is all about tensions and all about conflicts of norms, and that is good because that's what we like, right? It's what's basically paying our bills. So that's a good thing. And to bring you another tension, it's the one that is raised by Article 4, Paragraph 2 on the national security exception. On page 120 of your book, you correctly state that this provision, Article 4, Paragraph 2, underlines that any matters relating to national security of the member states remain their exclusive competences. However, current developments in the common security and defense policy are less about the national security of individual member states and more about the security of the Union as such, as a whole, which, by the way, on the basis of the treaties, is a Union competence. So CSDP is a Union competence, not so much a member state competence. It's to be supported by the member states, as you know. So to keep everything very short, the question would be, how would you interpret Article 4, Paragraph 2 in the light of this Union competence to establish a security and defense policy, given also the recent developments, for instance, that the Commission is increasingly involved in in security and defense issues through all kinds of things, including, for instance, the European Defence Fund, regulations on common public procurement, the ammunition production. There's a whole lot of things going on in Brussels on security and defense that are not so much related to this national security exception. The question then in the end is there still such a thing as national security?
Highly esteemed opponent, thank you for that provoking question. Is there? I think yes. I think yes, there is still national security because, again, even if it's what you mentioned as a union competence and that mostly or would affect the security of the union, the European Union, still it is a union of separate individual states, and it may depend on which member state you ask, on whether national security has more or less evolved to European Union security or not. I think that the Danish will, for instance, definitely not agree with that because they actually didn't sign up. So I think it really depends. Some member states may have the idea, and I'm pretty sure the Commission and that the European Union as a whole has the idea of this European security, and that national security as such has turned into European Union security. But I think that still, if you look at the recent case law and the position that EU member states, individual member states took there, is that still they highly appreciate and cling on to their national security, their interests. Also because, I mean, if you look, but that's practically speaking, how is the security then done? For instance, if it is about the mass retention of data, which is focused on protecting the security, those are efforts that are mostly done still on a national level. And in fact, if you look at those developments on an EU level, you'll time and again see is that it really does not develop in a unified European Union where it is sort of the federal states of the European Union. It's still much this individual interest that I see.
Professor van der Meij.
Yeah, my second question is also about this Article 4.2, national security. It states, the article or the provision, that national security remains the sole responsibility of each member state. Now, clearly, the EU has not been given powers for it. The powers are still in the hands of the member states. When I read your book, you seem to interpret this Article 4.2, this sentence in Article 4.2, that national security is almost like an island totally beyond the reach of EU law, as if it can never be affected. It must, the most minimal impact is prohibited, let's say. And you have to explain to me why you seem to give such a strict interpretation of it. There are many topics mentioned in the treaties where the treaty quite clearly says this is the sole responsibility of the member states. The EU has to stay away from it. But the court is always saying, and there is, and as far as I know, no exception to this rule, that even in matters which are falling within the exclusive responsibility of the member states, EU law must always be obeyed. Even nationality law of all matters. So in relation to your topic, the EU institutions have powers when it comes to the environment, data protection, criminal law, and so forth. Does that mean that the activities in these fields can never in any way indirectly potentially affect national security? You seem to be very protective of national security, and is that compatible with developments in other fields of EU law?
Thank you very much, sir. Highly esteemed opponent, thank you. I think that this goes back to the research question, where you will see is that the conflicts that dual NATO-EU member states have to face. Yes, from an EU perspective, this is indeed the EU perspective, where also the CGEU has always been very adamant that yes, it is the sole national responsibility, but we still have EU law. But you also signed up to the loyalty clause, so you have to do whatever it takes to apply and obey to EU laws. However, we also signed up, dual NATO-EU member states.
You may briefly conclude your reply.
Yes. Dual NATO-EU member states also signed up to NATO obligations. And since national security and security of all those members is inextricably linked to each other, also to members who are not members to the EU, that is where what the basis is for this, for my approach.
Jarin Nijhof, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company await the results of our deliberations and our return here in this room.
The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Long road to the south side. 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. The line, I know you know that I can't read your mind. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile. Long road to the south side, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off. Take the mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. It's a better future that we go for. And even though these nights seem long, I know that I am never on my own. Know you've won the battle once you've grown. Southside, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. Long road to the south side, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. Years can't fly by now, don't waste all your time. 'Cause I'll go the extra mile.
Jarin Nijhof, the degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taken into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professors Wiedmar and Muller are authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisors to take the floor.
Belooft u dat u altijd volgens de beginselen van wetenschappelijke integriteit te werk zult gaan, eerlijk en zorgvuldig, transparant, onafhankelijk en verantwoordelijk?
Dat beloof ik.
Krachtens de bevoegdheid ons door de wet toegekend, volgens het besluit van de commissie hier tegenwoordig, verklaar ik hierbij u, Jarin Nijhof, tot dokter te bevorderen en u alle rechten te verlenen die daaraan volgens wet en gewoonte zijn verbonden. Ten bewijze hiervan overhandig ik u nu de bul door rector, secretaris en overige leden van de promotiecommissie ondertekend en met het groot zegel van de universiteit bevestigd. Dr. Nijhof, we met toward the end of 2018 when we launched the first workshop on the questions of international institutional law, which opened the very fruitful cooperation between our faculty and the Allied Joint Force Command Headquarters Brunsum. You told me that you were a graduate of our faculty and that you had an idea of writing a PhD on the conflict between NATO and EU obligations of dual member states. The questions you were asking at the end of 2018 were very topical, but we could not have known at the time what pressing challenges to European security were just around the corner, and that you would be the first person to analyze the legal regime of dual members, Finland and Sweden, which were back in 2018 still firmly neutral states. But let's go back to 2018. I was convinced that you had a very strong topic, but was not convinced that I had enough capacity to accept another PhD supervision. Yet, the more I was talking to you, the more I was convinced that the more I was realizing that an excellent researcher was standing in front of me, that you knew exactly where the legal problem was, and that you knew exactly what needed to be written. Your thesis is different than most theses because you came from practice. You were not interested in imposing a meta-theory top-down. You showed us, bottom-up, how scholarship can solve practical issues. You showed us how scholarship can be used as a tool to fix concrete problems that you practitioners are dealing with. But Jarin, this still would not have been possible without understanding and support of several other people, many of whom are present here today. Your employer, US Army Netherlands Law Center in Brunsum, and your colleagues there were very understanding in giving you the time and mental space to pursue this highly important project. Maar het belangrijkste is je familie, Jarin, en je vrienden. De staan van je vrouw en je kinderen was belangrijker dan wat dan ook. Als je promotor bedank ik nadien Julien en Floris voor het begrip dat papa moest gaan schrijven. Nu ben je terug. Jarin, de pandemie was niet makkelijk. Hè? Je vertelde me dat je op een gegeven moment overwoog om te stoppen. Maar dan ging je fietsen, samen met je oude vrienden, je paranimfen vandaag, die je vertelden. Jarin, je moet volhouden. Je moet dit afmaken. Jarin, het is belangrijk om vrienden te hebben. Het is belangrijk te fietsen. Het leert je hoe je de top bereikt om te genieten van het mooiste uitzicht. Ik heb maar van één ding spijt. Dat we nooit samen zijn gaan fietsen. Maar goed, dat was misschien niet zo nodig. Omdat de hele wereld weet dat Sloveense wielrenners altijd te snel zijn. Dr. Nijhof, do enjoy the beautiful view from the top. You really deserved it. And now I give the floor to Dr. Wim Miller, your co-supervisor, who I also thank for his excellent contributions to this project.
Dank je, Jure. En ik ga ook in het Nederlands verder, omdat iedereen het hier verstaat eigenlijk. Dr. Nijhof, Jarin, ook ik feliciteer je van harte met het glansrijk behalen van de eindstreep na deze lange rit. Die bestond wel uit wat meer etappes dan we hadden voorzien toen wij in 2019 kennis met elkaar maakten. En net toen je een beetje op stoom begon te raken, sloeg de pandemie toe. En uiteindelijk heeft het, zoals Jure ook al zei, een paar jaar langer geduurd dan je van plan was. Maar uiteindelijk sta je hier met je bul en omringd door familie en vrienden. Gefeliciteerd. En naar ik heb begrepen, ook met een jarige vader. Dus ook van harte gefeliciteerd, meneer Nijhof. Ook met uw verjaardag en met de prestatie van uw zoon. Ik weet nog goed hoeveel het voor mij en mijn vader betekende toen ik op dezelfde plek stond. Dus. Zo, Jarin, gezien je professionele achtergrond lijkt het me toepasselijk om je te omschrijven als een good soldier. Het was een genoegen om je te begeleiden. Je communiceerde heel volledig, heel punctueel. Veel punctueler dan ik eigenlijk. En belangrijker, je reageerde bijzonder adequaat op feedback. Ik hoefde de punten die ik had vaak slechts heel beknopt te maken. En vervolgens ging ik ermee aan de slag. En het resultaat bleek altijd nog beter en grondiger en diepgaander dan ik had verwacht. Dit laat zien dat je niet alleen een good soldier bent, maar dat je ook veel meer in je mars hebt. En je bent een uitstekend jurist. Je hebt nu aangetoond bij te kunnen dragen aan de academische ontwikkeling van het recht. En de mooiste illustratie hiervan is denk ik nog wel dat je onderzoek ook de aandacht heeft getrokken van Martin Koskiniemi. Een van de meest toonaangevende denkers in de afgelopen decennia in het internationaal recht. Die dan vooral bekend staat om zijn kritische aanpak en zijn kritische reflecties. Maar ooit begonnen is als jurist voor de Finse regering. En die Finse regering ook nog steeds van advies dient. En laat die regering nu net bezig zijn met de zaken waar jij jarenlang onderzoek naar hebt gedaan. Ik hoop daarom dat we in de praktijk, zowel in de praktijk als in de academische wereld van je zullen blijven horen. Nou, ten slotte wil ik ook nog graag even terugkeren naar de heuvel waar je tegenop bent gefietst. Want een paar maanden geleden kwam ik erachter dat wij niet alleen generatiegenoten zijn, maar ook nog een muzikale voorkeur delen. Toen ik jou en ik weet ook je paranimfen tegenkwam op een concert van de Schotse zanger en dichter Derek Dick, ook wel bekend, of beter bekend onder de naam Fish. Een concert trouwens waar ook ons head of department aanwezig was. Dus, ja. Maar goed, voor Fish was de view from the hill een illusie waarvoor hij veel te veel had opgegeven en waar hij mee moest afrekenen toen hij afscheid nam van zijn band Marillion, helemaal aan het einde van de jaren 80. Maar de muziek die zij samen hadden gemaakt was zo goed dat hij alles wat zowel Marillion als Fish daarna hebben gedaan nog steeds in de schaduw zet. En daarom speelde Fish tijdens dat concert ook heel veel nummers van Marillion. Gelukkig is voor jou het uitzicht vanaf de heuvel alleszins waarachtiger. Het werk dat je ervoor hebt verzet zal ook van waarde blijven. En ik hoop dan ook dat je lang zal genieten van het uitzicht dat je nu hebt bereikt. En misschien met wat lavendel erbij en onder het genot van een White Russian. Gefeliciteerd, Jarin.
Yeah, dear Dr. Nijhof, also on behalf of our university and its Faculty of Law, many congratulations on the degree that you just acquired. We just heard it's the second degree that you have received from this university. This is the highest one we have available, I always add. And of course, it's also great to see that you like peaks, and here at the mountain you came to the right place, but that you already knew. Many congratulations to you, to your paranims, to the supervisors, and indeed also to all your family and friends, both present here in our beautiful aula, but also watching this ceremony online. I have one more practical remark, which is that the young doctor invites everyone present here to the reception that will take place in the refectorium of this building. I would like to ask everyone present here in the aula to give right of way to the cortege when leaving this room. And we will still take the traditional photo of the young doctor together with the paranims and the supervisors and the beadle and the entire committee. Congratulations again. And with that, I also officially close this academic ceremony.